The following podcast is taken from a live broadcast on Inspire FM.
Hello and assalamu alaikum wa rahmatullah to all the listeners. Today I'll be your host, Mujeeb from Dotcom Solicitors. I'm one of the solicitors there, and we'll be focusing on the topic of disrepair in terms of dwelling properties and houses. So disrepair basically just reverts to when we talk about the disrepair needed in a property, we're just focusing on the condition that is required legally for the house, if that makes sense. As in, I've been to a few properties myself where you walk in and I wouldn't picture it as suitable or adequate living conditions for any human being. But again, the law now sets out certain provisions, setting certain guidelines to be followed, and certain guidances in place to be followed in order to prevent people in living in such conditions. Now, disrepair claims are mostly made against landlords, generally, and they're always made against landlords or the landlord's agents or housing associations. Now, so by law, these individuals like landlords, agents, housing associations, etc., are required to ensure that the property is kept in good repair. When this does not happen, you may take action under Section 4 of the Defective Premises Act and Section 11 of the Landlord and Tenants Act. These acts obviously cover all types of short-hold secure tenancies, or whether the property is owned by a private landlord, whether it's by a social landlord. Social landlord can be a housing association or a local authority, such as it could be Luton Borough Council, it could be Sanctuary Housing, or it could also be a private landlord who can be a company itself, or even a private individual or individual landlord. A landlord is generally responsible for keeping a property in repair, and the landlord's responsibilities include the structure and the exterior of the home or the house or the property. For example, the walls, the roofs, the foundation, the drainage, the guttering, external pipelines, the windows, the external doors, and fencing, etc. Also, sinks, baths, toilets, showers, the water pipe work within the house, the gas lines, the water lines, the electrical wiring. Again, we've spoke about tenancy agreements before, and we did cover this briefly, so I'm just not going to go into great detail. And you could look up our previous podcasts, and it's all covered there in detail as well. Water tanks, it depends what boiler you got. If you got the old water tank system, boilers itself, the radiators, gas fires, if there's any electrical fireplaces fitted in or fitted heaters, the landlord is responsible to make sure these things or these objects or structures are kept in good repair and good condition at all times. Reasonable does not mean it just looks reasonable. No, reasonable meaning they work up to a good standard that they ought to work at. And a landlord, no matter how hard they try, they can't actually remove themselves from such responsibilities, and they can't even put a provision within the tenancy agreement to say, I exclude any liability of my own from keeping the house in repair. And legally, the repair work, I mean, the most frequent question that's asked when it comes to tenants, they'll say, who's responsible for the financial burden implied by the repairs of the property? Is it me, myself, or is it my landlord? Now, the answer to that is it's the landlord. Unless you and your landlord have an agreement where the landlord says, you know what, pay for the repairs for now and take it out next month's rent. So, in essence, you're giving him less money because you've paid for the repairs, so that you deduct the repairs from your rent, monthly rent, and you give him the remainder. That again is between the tenant and the landlord. However, the landlord is actually responsible for the financial burden of the repairs. So now the question arises, when should the landlord make these repairs or fix these disrepair problems if we mention these to him? Now, the thing is, the landlord should make these repairs or conduct these repairs as soon as he's notified, as soon as he's aware that there's a problem. So make sure, as a tenant, your job is to make sure you have told your landlord about any repairs that are needed. So you, as soon as you know there's repairs, there's a pipe leak, or there's a pipe burst, or anything like that, or the guttering or the drain is blocked, your job as a tenant, or a tenant's job, is to inform the landlord straight away. And the landlord, then the onus falls upon the landlord to make sure that it's dealt with accordingly and effectively. Now, obviously, I don't want tenants to get the wrong image and think, okay, we've spotted the disrepair 12 o'clock at night, so our landlord needs to fix it straight away by 8 o'clock in the morning. No, you have to be realistic at the same time. We have to be reasonable. As a tenant, you'll have to be reasonable and understand, look, if it's a Sunday morning, there's no builders around, or the builders are off, or what have you, then you'll have to kind of make a recession and understand that, look, the landlord cannot get a builder until Monday, so you will sometimes have to bear the brunt of everything. So it totally depends on the situation as well, and the severity of the disrepair. But again, as soon as the landlord's informed, the onus is there on the landlord to ensure that the repairs are carried out and conducted in an effective and efficient manner. Now, for tenancies that began on or after the middle of January in 1989, the repair responsibilities actually extend to the common parts of the building too. For example, entrance halls, stairs and lifts, in cases where they're living in flats, etc. So yeah. Now, sometimes your house could be in such a bad disrepair condition. I know it's very unlikely and it's not something that you see every day in your day-to-day life, but I assure you, as a solicitor working in the housing department, you see this all the time, where people are actually living in conditions that is just absurd, it's just diabolical, that it's kind of hard to even comprehend how a person could live in such conditions. And personally, from personal basis, I'm not talking as a professional here, I'm talking on a personal basis, seeing some pictures of some places where these people live is, I wouldn't say it's safe to live in such conditions. And personally, I wouldn't want anybody to live in them conditions. So, if the home or the property isn't safe for anyone to live in, there's an act that's recently come around, and that's the Homes, Fitness and Human Habitation Act 2018. It amends Section 8 and 10 of the Landlord and Tenants Act and adds to it so that the tenancy agreement beginning after the commencement date that will be mentioned, the middle of January 1989, implicitly contains a covenant that the dwelling must be fit for human habitation at the commencement of the tenancy, and will remain fit for human habitation during the lifetime of the tenancy. And it does not apply to tenancies which began before then, except for existing periodic tenancies, which also have all these new sections annexed into the previous acts. So the obligation to ensure that the dwelling is and stays fit for human habitation even extends to all parts of the building to which the landlord has an interest, meaning the landlord of a flat has an interest in the hallway leading up to the flat. He or she as the landlord or as the housing association have an interest in the lifts in the property. They have an interest in the staircase leading to the floors of the property, because obviously they own the property itself. And also they have an interest in the retained parts, i.e. the external wall, the roof, the communal bin areas, if there are any, the entrances, the hall entrance as we mentioned, the staircase of the flats, the lifts in the flat, etc., etc. Now, in order to establish or determine whether the dwelling is fit for human habitation or not, there are few factors that should be considered, as in, firstly, you need to look at the condition of the property. Is the property free from damp? Is there any water? Is there a water supply within the property? Is there adequate drainage and sanitary conveniences within the property? Is there adequate natural lighting and ventilation in the property? Now, expert evidence from a surveyor, including a surveyor employed by the landlord, is sufficient in order to establish that. As with the landlord's repairing obligations, the landlord will have a reasonable period of time once notified. Like I explained before, you can't expect to tell your landlord, say early mid-morning or late morning on a Sunday, and expect him to get it done straight away. You have to allow reasonableness there and ensure that you've given a reasonable amount of time for the landlord to act accordingly. And according to the severity of the situation, the landlord has to understand that the onus is upon the landlord to make sure the property's repairs are conducted, as in, if there's no water or lighting, if the lighting's all of a sudden gone off, it's now down to the landlord to make sure the lighting's back on, because you can't live in a house without lighting. It's not reasonable enough to consider it adequate for human habitation. Now, in terms of, does this happen often? The answer is yes and a no, because sometimes you will get cases where the tenants have informed the landlord of the disrepair issues. The landlord has not taken it upon himself to conduct the repairs, so then that's when the tenant will now say, look, I need to instruct a solicitor to fight my corner for me and put my claim forward. Now, again, like I explained, provided that the landlord has a reasonable period of time, once notified that his property is in a state of repair, in a state of disrepair, and it's not fit for human habitation, he has a reasonable amount of time, or the landlord has a reasonable amount of time to put right the defects. And if the landlord fails to do so, the tenant can sue for damages and bring forth a claim for disrepair. And again, it's the responsibilities of a landlord to make sure that the home is fit enough for human habitation. And if a home might be considered unfit for human habitation, for example, when there's a serious problem of damp and mold, meaning they're going to be inhaling the odor or the kind of smell, or if you like to say, from the damp or the mold. If it gets too hot or too cold, like there's not sufficient insulation within the property, or the insulation's gone poor, what have you, or it's overcrowded in cases where there's shared accommodation or a block of flats, or if it's infested with pests such as rats, cockroaches, rodents, etc., and if the property does not have a safe water supply. It categorically does not matter if the problem started at the start of the tenancy or only appeared later on. Now, it doesn't matter completely if it was there before the tenancy began, upon the tenancy beginning, or during the tenancy, or just occurred towards whenever. The obligation will always remain on the landlord, and the landlord will have to fix these defects or repair these defects, provided he is notified or they are notified. And then the notification can be from anyone. It could be from the tenant or even a visitor. The condition is not that the tenant must notify the landlord. It's whoever can soon. The obligation is upon any man to kind of vouch to the landlord, affiliate with the tenant. That's possible as well. Now, that's why it's important that as a tenant you inform your landlord of the disrepair at the earliest possible opportunity. Now, the obligation to repair is always going to remain with the landlord, whether it's implied or express. Now, just to talk briefly, I've got case law in front of me, but I don't want to go into great detail. But there's this particular case, just to give you an example. Now, the tenant himself, what he done was he notified the landlord. So the landlord was notified of disrepairs. The landlord ignored the notification, but acknowledged it at the same time. Done nothing about it. So this individual decided to take action against the landlord. He put a claim against the landlord of disrepair. Now, in the possession proceedings, so what happened thereafter was the landlord tried evicting the property, evicting the tenant out of the property and getting back his property. So he done a counterclaim of £22,000. The court dismissed the counterclaim on the basis that they found that they failed to uphold or adhere to the notice of disrepair. Now, so that just gives you a little brief overview of how disrepairs work. Now, one must be thinking, where do disrepair obligations actually come from? Disrepair obligations are actually contractual obligations in reality. The tenancy agreement may impose express obligations on the landlord, on the tenant, or on both, to the extent that the express terms go beyond any implied term. They will be binding on the parties. However, the express terms cannot, without the authority of the court, reduce or negate the repair obligations which have been put into place by statute on the landlord in accordance to Section 12 of the Landlord and Tenants Act 1985. Now, there's also common law implied terms. Now, in terms of letting furnished dwellings for immediate occupation, is an implied term that the premises will be fit for human habitation at the start of the tenancy agreement. So it doesn't need to be explicitly mentioned, it will be automatically implied that that should be the condition. Now, there's another case against Liverpool City Council and Mr. Irwin. The agreement itself imposed no obligation on the landlord to keep the common parts of the large block of flats, such as the lifts, stairs, lighting in the hallway, etc., in repair. But the court held that it is necessary to imply a contractual obligation on the landlord to take reasonable care to maintain those conditions in those common parts in a state of reasonable repair and efficiency. Now, at the same time, the tenant had an implied obligation to use the premises in a tenant-like manner. There's an implied obligation. There's an implied obligation on the tenant to allow the landlord access into the property to repair the property, to repair the defects as well. So, if the landlord needs access to your property in order to rectify the disrepair issues within the property, as a tenant, one should grant them access. It is implied that is an implied obligation upon a tenant to grant the landlord access. Now, according to statutes affiliated around this subject, I spoke and I've mentioned the Landlord and Tenants Act, but there's certain implied terms from this Act, namely Section 11 of the Act, which are implied into certain tenancies granted after the 23rd of October 1961. Now, what are these? There's a contractual obligation on the landlord to keep in repair the structure and exterior of the dwelling houses, including drainage, gutters and external pipelines, to keep in repair and proper working order the installations in the dwelling house for the supply of water, gas, electricity, sanitation, to keep in repair and properly working order the installation in the dwelling house for space, heating and heating water. So that's basically what's implied by the Landlord and Tenants Act, that the structure is in good repair, the exterior of the dwelling house is always in good repair, including the drainage, gutters and external pipes, they're always in working order, to make sure the installation of the dwelling house, such as the water supply, gas, electricity and sanitation, is always in good repair, and to keep in properly working order the installation of the dwelling house, such as the heating and the hot water supply or the water system, to make sure they're always running up and running properly and in an adequate manner. Now, the provision also applied to all weekly, monthly and yearly periodic tenancies or even fixed term tenancies, provided that the period granted was less than 7 years. Now, the statutory implied terms on the tenants also, in accordance to Section 11 of the Landlord and Tenants Act. Now, these implied terms are that it implies that the tenant's agreement on and the tenant agrees on an obligation that the tenant will allow the landlord or any person authorized by him in writing to enter the rented property to view its condition and the state of repair. So if the landlord wants to get access to your property as a tenant, you should allow him access if he wants to inspect the property and see that everything's in working order. So that's the landlord's right over you as a tenant. Now, there is a condition. The landlord cannot just walk and steam into somebody's house or just not knock on the door and say, yeah, I've come to check my property, or yeah, I want to walk around, or yeah, I've come to your house, you weren't at home, make sure you're home. He can't just ring you and say, yeah, I'm coming, don't go out. And the law will not allow that. So generally speaking, what happens is if the landlord wants access legally, there's a condition that he needs to meet. The landlord needs to give the tenant 24-hour notice, informing the tenant that the landlord will be there, and the landlord will be arriving at a particular time to inspect his property. For example, if the landlord texts you 5 o'clock today, saying I'll be in at 6 o'clock tomorrow, he's giving you what's legally considered sufficient notice to get access into his property in order to inspect the condition of the property, and that's the right of the landlord over you as a tenant. Now, I think it's time for our break, and inshallah, stay tuned with the Ask Your Lawyer show, and once we return from the break, we'll continue further, inshallah. Assalamu alaikum wa rahmatullah.
You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Hello, assalamu alaikum wa rahmatullahi wa barakatuh, dear listeners, and welcome back to the Ask Your Lawyer show at Inspire FM. I'm your host for today, Mujeeb of Dotcom Solicitors, a solicitor of Dotcom Solicitors. As I briefly mentioned, I specialise in housing and civil litigation. And today we were talking about disrepairs. I will round off towards the end. I will take a couple of minutes and recap over everything that we've spoke about through the course of the last half an hour. Now, however, moving forward for those that have been listening from the beginning, and they are also we covered the last point we covered was the common law implied terms of the common law obligations when it comes to disrepairs and who the onus falls upon. Now, there's also obligations in tort. Now, the obligation in tort does not generally give a tenant the right to require repairs to be carried out, where they sometimes provide a remedy for any injuries or damages suffered as a result of the disrepair of the properties. Now, that's briefly mentioned in the Occupiers Liability Act 1957. The section 2 of the Act expresses, and I'll just put it in a nutshell, suggests that the landlords have a common duty to take care of such repairs in all the circumstances of the case, and if it's reasonable to see that the visitor will be reasonably safe in using the premises for the purpose for which he is permitted to be there. So the Occupiers Liability Act will also cover under the obligation in tort any visitors that you have visiting you in your property. So if they're injured or they suffer as a consequence of the state of disrepair of the premises, then your landlord is also held responsible on their behalf. Now, the moving swiftly forward, because as we know, there's Maghrib Adhan coming up as well, so we'll have to round off at some point in the next 20 minutes or so. We also briefly mentioned previously the Defective Premises Act. Now, the Defective Premises Act requires that your landlord owes you a duty of care, which is also obviously set out within the Act itself. And the duty of care includes a duty to prevent personal injury or damage to the property caused by defects in your home. So your landlord has that duty and has the onus upon himself, and the landlord owes the tenant a duty of care to ensure that the disrepair there's no disrepairs there, because, God forbid, maybe due to the disrepairs it could cause, like as in mold in the walls, can cause a little child asthma or breathing difficulties and suffocation, etc. Or we can, moving forward, if the property is in a state of disrepair and the windows are not good or anything like that. I mean, winter months can get extremely cold. It gets extremely cold in the winter. That could result in a person catching pneumonia or anything of the sort. So obviously the landlord owes you a duty of care, and the onus is upon the landlord to prevent such things happening. Because again, obviously I'm not going to say just because you get pneumonia it's because of your landlord. No, as in if it's caused through the disrepairs, then the onus is upon the landlord. Then the duty is also owed to you, your family, your friends and visitors that come to your home to visit you. This is all covered within the Act. And the duty is owed because your landlord is under an obligation to repair and to maintain your home. And the landlord also has a right to enter the property to carry out the maintenance work on repairs. As mentioned previously, please, there is a condition on that, and that condition for a tenant is only that the only condition that the tenant needs to know that the landlord has to fulfill, that the landlord needs to give you 24 hours notice. Upon 24 hours notice, the landlord is allowed to get entry into his property, their property. The duty is owed if the landlord knows. Again, this is another condition. The duty is only owed if the landlord knows or ought to know or foreseen or have knowledge of the repairs, even if you haven't told your landlord. So if you haven't told your landlord and it's obvious that the landlord knew or should have known or could foresee this happening or this repair is due, then that's sufficient. But again, it's the onus. Generally, what we always advise our clients, okay, if they come in and say we haven't told our landlord, we say, look, don't assume, because in law and in legal terms or in legal situations, we do not base our judgment and our work on assumptions. So legally, sitting in a courtroom, I mean, I'm just giving a hypothetical situation, and if you're a tenant and you say to the judge, yeah, I didn't tell my landlord, you brought forth the claim of disrepair, and the judge's first question is going to be, did you inform your landlord? You say no, because he obviously should have known. I'm so sorry, but to a judge, that's not a sufficient sufficient explanation. The judge, 9 times out of 10, will not take that as an adequate response, to be fair. So we always do advise our clients, please just inform your landlord. It's not going to harm you. Just get into contact with the landlord and let him know before taking any matters further. Now, there's certain procedures thereafter that have to be complied with and followed, such as the civil procedure for civil claims. And in accordance with the pre-action protocol, it actually explains the conduct and sets out the steps that the court would normally expect the parties to take before commencing to a claim or proceedings for a particular type of civil claim. So there is also a pre-action protocol for housing disrepairs. So I know a lot of you probably heard about the pre-action protocol for personal injury, but there's also a pre-action protocol for housing. You can get access to that for those who really want to spend the time reading through a bunch of legal wording and legal procedures. You could get access to it on the Ministry of Justice website, I believe. Google it, it'll come up, it'll take you through a .gov UK link, and eventually you'll find it. Now, the aims of the protocol are pretty easy and pretty fair. It's to avoid any unnecessary litigation, promote speedy and appropriate carrying out of any repairs which are the landlord's responsibilities, ensure that the tenants receive any compensation to which they are entitled as soon as possible, and promote good pre-litigation practice, meaning letters back and forth, mediations, etc. And this also includes the early exchanges of information. So as the defendant's solicitor, you'll be saying, my client didn't know this is our proof, this is the exhibits we got together. As a claimant solicitor, you'll be doing the same thing. These are my client's instructions, this is our exhibits, this is what our client's account is, etc. And generally we'll say try, according to the pre-action protocol for housing, you should try to resolve a matter before or without a court hearing. Now, although most claims are brought by the tenant upon the landlord, the pre-action protocol for housing is not just limited by that. It covers claims by any person with disrepair claim, including tenants, leases, and members of the tenant's family, visitors of the tenant, and the use of the word tenant in the protocol covers all such people. It's just not a tenant himself who claims within the pre-action protocol. Now, the pre-action protocol also covers all claims or all conditions that are set out in Section 11 of the Landlord and Tenants Act and Section 4 of the Defective Premises Act. Any common law nuisances and negligence, and those brought under the express terms of the tenancy agreements or lease. It does not, however, cover claims brought under Section 82 of the Environment Protection Act, and claims under that act are obviously heard in the magistrates' court. So your best bet would be going to a criminal law solicitor. And I know we have frequent solicitors coming in from Liberty Law Solicitors and Wolf & Co Solicitors, covering various criminal law aspects and immigration aspects also. So, I mean, if you have a question about that, Environmental Protection Act, or want to know how it's interlinked, by all means you could always speak to them and ask them to enlighten you. Now, as mentioned, what the aims, as we mentioned, the aims of the pre-action protocol for housing. As a solicitor, we would advise our client to consider alternative dispute resolutions, and its procedures would be more suitable than litigation, and if so, try to agree which form to use. Now, the reason we say that is sometimes better, we always advise our clients, it's sometimes better and cheaper to settle before the hearing itself takes place, because after the hearing it's costly business, even on a financial term. It can be very costly. So we always advise that it's settled out of court and as swiftly, as quickly as possible. Now, if it does get to court, both the landlord and the tenant will be required by the court to provide evidence that alternative means of resolving the dispute were considered and taken into consideration. It cannot just be like we always say to our clients, you cannot just walk in through the door and say, no, I'm just going to take him to court or take them to court and I don't give a damn. Unfortunately, it's not that easy, because the first question more or less will be, or the court will want to see, what actions have been taken pre-hearing. So has there been an offer made? Has there been any talk of settlement? Has there been any chance of a mediation meeting? Have you tried any forms of ADR? Now, if you have exercised all the avenues, can't come to common ground, ends up in the court, and the court is satisfied, and you can prove to the court that reasonable measures and steps were taken, then it's okay, it's going to be sufficient for you. But if you can't, then unfortunately the court might order you to, or adjourn the hearing and say, go back and consider alternative dispute resolutions. Now, the courts will always consider litigation to be the last resort, and that claim should not be issued while a settlement is still actively being explored. So a claim should not be issued, as in you shouldn't issue court proceedings if you're still trying to explore certain avenues and trying to come to certain settlements. Now, the courts, the parties, the landlord and the tenant should be aware that the court will take into account the extent of the party's compliance with this protocol when making orders about who should pay the costs. So whoever complies with the orders is less likely to get the costs, in essence. Now, a tenant's letter of claim, that more than likely in a not more than likely, in a disrepair claim, when we're acting for the tenant, or when a housing solicitor is going to be acting for a tenant, the first thing, after obviously the procedural steps have been carried out, such as the client gives letter of authorities and etc., the first thing we'd write to the landlord is a letter of claim of disrepair. Now, the tenants are required and should send a letter of claim of disrepair to the landlord at the earliest reasonable opportunity. Now, again, a letter of claim for disrepair you can find on the internet. If you Google search it, it'll come on the gov.uk website, or will be on a relevant legal website or government body's website. I think you get access to it through the Ministry of Justice pool as well, if I remember correctly. Now, the letter may be suitably adapted as appropriate. So the letter that you'll find the precedents online can be adapted and can be changed to suit your needs. Now, the letter of claim should contain certain details, and I've listed out here for your information some of the details that should be within the letter. The letter should contain the tenant's name, the address of the property, the tenant's address if the tenant's left the property, and the tenant's telephone number and when he's accessible to talk, or they're accessible to talk. Detailed descriptions of the defects on the property, included outstanding defects, and that'll be also found online, and you'll find a specimen of the schedule online, which you could always amend and adhere to, add and subtract to. History of the defects and how they started, and if there's been any attempts by the landlord to rectify these defects. And also details of any notifications previously given to the landlord in terms of informing him of the conditions of the disrepair. Now, that being said, the effects of the defects on the tenants, tenant here meaning the tenant's family, tenant's visitors, etc., and the identities of all other persons who plan to make a personal injury claim, and brief details of their personal injury claim. So if there is any visitors or family members that have suffered personal injuries from subject to the disrepairs, then details of how they suffered them injuries and what they suffered should be disclosed. And details of any special damages, again, you could find a schedule of special damages online. The proposed expert, if there was a proposed expert surveyor who went into the properties to establish that it was in a state of despair and it was not fit for human habitation, and also the letter of instruction that was sent to the expert who surveyed the property. And moving forward, the tenant. Now let's just finish off here, because we're running out of time as well. Now, these are the basics of what should be included in the letter of claim. However, the letter of claim, like I said, you'll find the precedent for it online. If you just Google search it, it'll come up. Now, that itself, to be fair, is just the basic core of what a person can include in the letter of claim for disrepair. However, like I mentioned previously, you will be adding and subtracting from it, and to be honest, in 99.9 cases, you'll probably just be adding to it, and then you'll issue that letter of claim, and you'll give the landlord sufficient amount of time to respond to you. Once the landlord responds to you, the landlord, obviously under the pre-action protocol, has 51 days to reply. And once the landlord replies, you then take it further. Whether the landlord suggests that he wants to settle, or the landlord suggests he wants to carry on with the back and forth writing, litigating, pre-litigating, back and forth writing and pre-litigation, etc. Now, then the final call will be obviously with what you get when both of you are out of the tunnel, what result you get, whether you decide that you have settled or not. Now, today we've covered quite a bit. However, we've not covered the whole of disrepair. We've only covered a third, to be fair. So we will revisit this topic. There will be a part 2 of disrepair. And in part 2 of disrepair, we'll finish off the whole topic in its entirety. And just to basically go over the general overview before I finish off today, we spoke about disrepairs and we went over who has the rights of disrepair and what obligations and rights are carried by whom and who the onus falls upon. And we kind of briefly explained what is disrepair, what needs to be kept in good repairable, good conditions in accordance to the law. We went over the Landlord and Tenants Act. We went over the Defective Properties Act. We went over the Home Fitness for Human Habitations Act also, which is all included within the topic of disrepair. We also went over the pre-action protocol for housing disrepair also. And like I said earlier, the general responsibility of ensuring that all disrepairs are up to date and all repairs are conducted within the property fall upon the landlord themselves. However, there are 2 conditions that are to be met by the tenant. One is to allow the landlord access into the property and notify the landlord of the disrepairs. Now, when it comes to the landlord getting access to the property, it's not just him knocking on the door, as explained. Legally, the landlord has to notify the tenant with a 24-hour notice, which could even be a text or a phone call or even a letter posted through the letterbox. Thereafter, after 24 hours, the tenant has to comply with the law and the legal regulations and allow the landlord access into the property. Now, thank you for your time today. Once again, I'll apologize that we couldn't finish the whole segment off today. So there will be a disrepair part 2. Inshallah, I'm hoping that that'll be in our next session. And thereafter, we are going to cover homelessness, because a few brothers, surprisingly, I haven't told the brothers in the studio, have seen me outside and said, look, we want you to cover homelessness. So inshallah, that will be our next topic after we finish disrepair. And inshallah, assalamu alaikum, and enjoy the rest of your evening. Assalamu alaikum.
Thank you for listening to our podcast. Why not tune in to our live stream at inspirefm.org and follow and subscribe to our social media platforms at Inspire FM Luton.